Hi, I'm Anna Denton-Jones from Refreshing Law, and in today's session I want to talk about one of the first cases to reach tribunal dealing with an issue that lots of employers will be familiar with from coping with the pandemic. Now, this is recorded on the 22nd of June 2021, and the particular case that went to tribunal in Manchester happened to involve a housing association, and it involved a 0 hours worker rather than an employee, but for our purposes that probably doesn't really matter. It involved a situation where the employer in March 2020 sent certain workers, in this case home, because they appeared on the government list of clinically vulnerable. In this case it happened to be a pregnant worker, so the case was a claim by the worker that she'd been treated less favourably for that reason, but it could equally have been a disability related case if somebody was sent home for other clinical vulnerabilities, or indeed being extremely vulnerable, being the other phrase that we've all got used to that the government used. Now, this lady was sent home for a number of months. She was paid during that period, but there was a big delay in being able to get her back to work, not least because the company, the employer, was struggling to obtain the perspex screens that were needed to place between desks for a while, because there was a sort of worldwide shortage of perspex at that point. This lady did raise a grievance. Whenever somebody has raised a grievance, there's always the potential, if there is a protected characteristic, for the individual to try and argue, as this lady did, that after I've raised a grievance, I was then subject to acts of victimisation. So the raising of the grievance being the protected act, and then arguing certain detrimental things happen to be after that. In this particular case, the lady was complaining about maternity pay issues and issues around some extra holidays. In both cases, in this particular case, the judge found that there were explainable, if you like, misunderstandings in relation to both those issues, so the employer hadn't actually done anything wrong. But the key issue for our purposes is around that sending home and the extent to which those who have been excluded from the workplace might then be able to clobber the employer later on, saying that it was an act of discrimination. Obviously, the judge in this particular case was aware of the floodgate opening potential of that kind of argument, and clamped down straight away on that argument, effectively saying sending you home wasn't an act of unfavourable treatment. It was just your employer acting on the basis of government advice. The delay in you being able to return to work was not an act of unfavourable treatment, but merely something where your employer was trying to comply with the health and safety advice around social distancing, etc. So an employer-friendly decision. Obviously, every case is going to stand and fall on its own merits, but it does at least hopefully give us some reassurance that the kinds of decisions that judges are making at the moment are very sensible around pandemic related things. So hopefully that will be good news to you. If you have got any questions, please do let me know. It's adenton@refreshinglawltd.co.uk, and see you next time.